Racial discrimination and injustice pervade virtually every aspect of our criminal justice system. This video focuses on racial bias in jury selection. Many people think that the Sixth Amendment guarantees the right to a trial by a jury of one's peers. But it doesn't. Rather, it guarantees every criminal defendant an impartial jury. The Constitution doesn't say any more than that, so it has been up to the Supreme Court to figure out what an impartial jury means. One of the very first Supreme Court cases involving racial discrimination in jury selection was Strauder v. West Virginia. In 1873, West Virginia adopted a state constitution that prohibited non-whites from serving on juries at all. Taylor Strauder was an African-American man who was convicted of murder by an all-white jury. He appealed to the Supreme Court, claiming this violated the Equal Protection Clause. Surprisingly, the court agreed with him in a unanimous decision. It said, the very fact that colored people are singled out and expressly denied by a statute all right to participate in the administration of the law as jurors because of their color, though they are citizens and may be in other respects fully qualified, is practically a brand upon them affixed by the law, an assertion of their inferiority, and a stimulant to race prejudice. However, the court also noted that it would be perfectly acceptable for states to exclude women from juries, or to restrict jury eligibility to only those with a certain amount of education. Nevertheless, the Strauder case established the principle that individuals cannot be excluded from juries solely because of their race. Of course, just as they did with voting rights, many states devised various clever ways of reducing minority membership on juries anyway. In many states, racial bias exists right from the start. Each state needs to figure out which people to call for jury duty. Some states use voter registration lists to generate their jury pools. But older, wealthier, white people are more likely to register to vote than the young, the poor, and minority citizens, and thus they are more heavily represented in the jury pool. On the other hand, many states call anyone with a driver's license. This is the most egalitarian system, but even this system has a slight bias. Prospective jurors travel to the courthouse for jury selection. First, a hardship hearing is conducted in which jurors have an opportunity to ask to be removed from the jury pool due to various work, school, or family commitments. As a result, older, retired people tend to be slightly overrepresented on juries. After the hardship hearing, the attorneys for both sides have the opportunity to remove jurors that they do not like. While the Constitution may guarantee an impartial jury is the last thing that the attorneys want. Both sides want a jury that is as partial to their own case as possible. Hopefully, the jury that emerges from this battle will be fair. Attorneys for both sides then have the opportunity to question potential jurors, and they have the opportunity to make challenges to their being seated. Attorneys have two different kinds of challenges they can make: challenges for cause, and peremptory challenges. In a challenge for cause, attorneys must state a specific reason for exercising the challenge. For example, they might ask that a juror be removed if they know, or are related to, the person on trial, or if they demonstrate a clear bias one way or another. The judge then has to decide whether or not to sustain the challenge and remove the juror. Each side gets an unlimited number of challenges for cause, because the decision ultimately rests with the judge. The second kind of challenge is called a peremptory challenge. Each side has a limited number of peremptory challenges. These are an opportunity for attorneys to follow their hunches. Attorneys may feel that a juror might be biased against their client, but they are unable to explain exactly why. They can use a peremptory challenge to remove such jurors unilaterally, without getting permission from the judge, and without giving any reason for doing so. For example, some prosecuting attorneys have a gut feeling that jurors with beards tend to be rebels and tend to question authority, and therefore they might be biased against the prosecution. Whether or not this is true, a prosecutor who was suspicious of a potential juror with a beard could have them removed from the jury pool without offering a reason. Peremptory challenges are a fundamental part of our justice system, but they are also prone to abuse, and can be used to harm minority defendants. This is true because most jury pools have more white members than minority members, and attorneys sometimes use their peremptory challenges on racial grounds. For example, in the Supreme Court case of Batson v. Kentucky, an African American named James Batson was on trial for burglary. Initially, there were only 4 African Americans in the jury pool, and the prosecutors used their peremptory challenges to strike all 4 of them. The resulting jury was all white, and it returned a guilty verdict. Often, prosecutors will make the argument that black jurors will be more sympathetic to black defendants, and therefore may be more likely to acquit. And this certainly may be true in some cases. It may also be true that white jurors are more likely to convict black defendants. During the murder trial of O.J. Simpson, public opinion polls showed that about 80% of all white people thought that Simpson was guilty, while about 80% of black people thought he wasn't. His criminal murder trial was held in Los Angeles with a mostly black jury, and it voted to acquit him. He then had a civil trial held in Simi Valley, with an all-white jury, and it voted against him. The question is whether attorneys can use their peremptory challenges solely to remove jurors on the basis of their race. The Supreme Court answered that question in Batson v. Kentucky, which is the subject of the next video.